Here are my 5 tips to help you communicate more effectively with those employment lawyers who you contact about your potential employment or wrongful termination case. Tip number 1, email versus calling. The vast majority of lawyers today would much prefer that you initially contact them by email than by phone. It's easier, it's quicker, and lawyers generally respond to emails much quicker than to phone calls. They don't have to check their voicemail, they don't have to play phone tags with you. And for all the obvious reasons, email is more efficient for most, but maybe not all lawyers. So consider contacting those lawyers that you would like to talk to about your case by email first. Many lawyers don't respond, and if they don't, maybe it's not the right lawyer for you to talk to. Keep your inquiries short and to the point. That's my second tip. So many people out there, so many potential clients attach a 30-page summary of their potential case, including all kinds of information that has nothing to do whatsoever with their actual claims. They start with the introduction about who they are and their previous jobs and their accomplishments and their education. What does it have to do with your case? Not much. There is no reason for any case not to be summarized in a few paragraphs, in one page. And the better your case is, the stronger it is, the easier it should be for you to put it in just a few sentences. Number 3, at the same time, be sure to include the most essential information about your potential case. And this should include your location, the location of your employer, date of your hire, date of your termination, if relevant, your most recent title, your most recent compensation per month or per year, the stated reason for termination, even if you disagree with it, the employer's reason for terminating you, versus what you believe is the true reason that you were terminated and why exactly and specifically you believe that. Tip number 4, share with the lawyer facts, not legal labels. Such terms as harassment, hostile, bullying, and even discrimination and retaliation don't really mean anything to the lawyer that will be reading your email. What does "I've been harassed" mean? Does this mean that your coworker or your boss used an N-word in one-on-one with you or in the presence of other people? Does it mean that he grabbed you sexually by I don't know, by your breast or by your genitals? Does it mean that someone threatened you? And if so, what did they do and say exactly? The word harassment doesn't mean anything. The word hostile work environment also doesn't say anything to the lawyer. So quote specific words that were told as precisely as possible to you, when and by whom, and describe specific actions. Assault and battery don't really say anything. Being punched with the left fist in my right eye and leaving me with a black eye, that does mean something. Abusing me physically versus pushing me against the wall and causing me concussion by hitting my head against the wall, those are two very different ways to describe the same thing. And the second, more specific way is so much better and so much more to the point. And lastly, tip number 5, avoid red flag terms and red flag words that scare away so many lawyers. And here are some random examples that some potential clients include in their initial inquiry. I have an easy case. I have a $100 million case, which is slam dunk. I'm shopping for lawyers. I fired my last 3 lawyers because they're not good enough. Writing emails in all caps suggesting that you're super, super, super angry. Anything that would communicate to the reader that you're emotionally unstable is going to scare away many lawyers. And the best lawyers out there also happen to be the most picky one. So follow these 5 simple tips when contacting lawyers about your employment case or any case, and the chances that more and better lawyers will respond to you quicker will be much higher.